morning. My name is Katie Perez, and I'm a senior associate here at Scott Legal PC. Today, we're going to spend some time talking about the L-1 and EB-1C visa requirements. I just want to make sure everyone can see my screen and that we are okay. Just one moment.
I'm sharing it.
Okay, sorry. Just wanted to make sure mine was good. Okay, so just a few things before we get started. Some of you may know that the firm was founded on an E2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E2 visa and has been on several different visas, including the F1, a TN, a B, and an H1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including the E2, E1, TN, L1, family immigration, national interest waivers, the EB-5, and extraordinary ability visas, and more. So we will continue this webinar series, doing at least 2 webinars a week on different topics. At the end of this webinar, we will send out several useful tools. We'll send you a copy of the PowerPoint presentation from today, a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. So this webinar will be recorded and will be available on YouTube. We will also send the link for that. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We'll also send you a link where you can arrange a consultation with one of our experienced attorneys if you would like to discuss your case in more detail. So if you have any questions throughout this presentation, please put them in the chat box and we will answer all questions at the end of the presentation. So for today, I will present the first half of the webinar. We are also joined by our partner, Kelly Weiner. She has a wealth of experience in adjudicating many different petitions within the family immigration, employment-based immigration, but especially those with the L and the EB-1Cs. So without further ado, we will get started discussing the L visa. Okay, so the L-1 visa is a non-immigrant temporary work visa that allows a company to transfer certain qualified employees serving in a managerial, executive, or specialized knowledge role from one of its foreign offices to the U.S. office in a related office. So there must be a qualifying relationship between the foreign and U.S. companies. The qualifying relationship between the foreign and U.S. companies can be that of a parent, subsidiary, affiliate, or branch. And then non-immigrant classifications for this visa are those of the L-1A and the L-1B. So the L-1 visa can be an option for a company that has been doing business for an extended period of time in the U.S., at least 1 year or more, and that company wants to send a qualified individual to the U.S. However, it can also be an option for companies that have never engaged in business within the U.S. So those companies want to come here looking to expand, and those companies who have not been doing business for more than a year within the U.S. would be classified as an L-1A new office. A new office is defined as an organization that's been doing business operating for through a qualifying organization for less than 1 year. So both the L-1A and the L-1Bs can be classified as the new office. So we'll discuss a little bit more specifically about each the requirements for the L-1A. Again, so sorry, the type of qualifying relationships can include a parent, affiliate, branch, or subsidiary. Here it is very important to look at how the companies are related. So that foreign company and U.S. company. It would be very important to look at documents such as the operating agreement, formation documents to really determine the ownership and control of each organization. Although you might define a company specifically as an affiliate, the regulations do have specific definitions for these types of relationships. So it does specifically define what an affiliate is, what a subsidiary is. So for example, you could have company X, they're owned by 3 people, A, B, and C, each person owning approximately 33% of the company. You also have the U.S. company Z, that's owned by A, B, and D, also each owning about 33% of this company in the U.S. So although a large portion of each company are owned by the same 2 people, this doesn't necessarily meet the definition of affiliate because it's not owned by the same group of people. There's one person that's different. So this is a very basic scenario. You could have different situations where people have different ownership, but you can have the control can be determined by, an operating agreement. So it is very case by case specific, but it is important to do an initial analysis to ensure that the foreign and U.S. companies do have a qualifying relationship that satisfies one of the definitions in the regulation. You must also show that the foreign and U.S. companies are both doing business on an ongoing basis. Doing business is defined as the regular, systematic, and continuous provision of goods and services. So therefore, you need to show both companies are actively engaged in business, actively trading. Typically, evidence would include taxes, invoices for sales, something of that nature. So there is no statutory minimum regulatory minimum requirement for what is the business activity, what is doing business. Determining doing business will be on a case-by-case basis. So it really does depend on the type of business, the needs of the organization. The government will just look at the petition holistically. So if you own a business which you're selling goods, and you only provide invoices to the government maybe for January 2025 and August 2025, and you have low revenues and no employees, the government likely question whether, this company is doing regular business. And then it would be your burden to explain how the company is doing regular business based on what the evidence you're submitting. Doing business requirement does impact the type of petition you'll file. So we did touch on this a little bit in the previous slide, but if you're coming to the U.S. to start a business, you've been doing business here in the U.S. for less than 1 year, this would mean that you would qualify for the new office. So with the L-1 visa, the U.S. company would have a year to get the company up and running to really do business, to meet the regulations, to show that it's, doing the regular, systematic, continuous provision of goods or services. With the new office, you don't need to show regular business at the time you file. Another consideration where you may have an organization that has existed for a year or two in the U.S., but it has not been engaged in this regular, systematic, continuous provision of goods. So that in this case, the company could be classified still as a new office. So as an example, say you incorporated 2 years ago, but the entity has just been passive, no sales, no trade, goods and services. This wouldn't necessarily qualify for an established office, but if you plan to start trading, start engaging in sales, you could apply and qualify for the new office. Doing business does not include the mere presence of an agent or office, so you do need to show the activity. Another requirement is that the employee has at least 1 continuous year of full-time employment abroad with a qualifying organization within the 3 years preceding the filing of the petition. The employee's prior year of employment must have been in a position that was managerial, executive, or involved specialized knowledge. And then there are very specific definitions for what is a manager, what is an executive, and what is specialized knowledge. And we will discuss those in a later slide. For the L-1A, which is the manager or executive, you can be approved for initial grant of up to 3 years. And then you can renew for in increments of 2 for a total of 7 years. Under the L-1B, which is the specialized knowledge position, you can also be approved for 3 years initially, and then renew in increments of up to 2 years for a total of 5 years. Within the L-1A visa, you can also recapture time. For example, if you spend a few weeks out of the year outside the U.S., you could possibly recapture that time. So under the L-1A, again, you can have a total of 7 years. For example, if you spend 3 weeks each year on vacation, you're back home visiting your family, you can take in those 3 weeks for each year, add it up, and that time outside the U.S. will not count against that 7-year clock. So it is helpful to keep track of your trips. While the government excuse me, may have your travel records, on occasion they don't keep, or they cannot obtain the the complete record. So it would be your burden to show that you are eligible to recapture the time. Okay, so we'll go to the next slide. What are the new office requirements? So a new office is an organization that, again, has been doing business in the U.S. through a parent, branch, affiliate, or subsidiary for less than 1 year. If the company is sending an employee to open the new office, there are some specific additional requirements. So we'll discuss those a little bit. So one of the additional requirements under the L-1A new office is that you must show the government that you have secured a sufficient physical premise to house this new office. The physical premise really needs to make sense with the type of business you plan on conducting. It also needs to You also need to show the government that you have obtained the type of lease or physical premise that you claim you will need within like your business plan. So, for example, if you plan on doing maybe an import-export business and you're telling the government you need a warehouse to house the goods, you've also stated that you will hire 7 employees in this year 1. If you, within your petition, provide the government with a lease that's maybe 100 square feet, no warehouse, there's only 1 desk, and it's not going to fit these 7 people. The government will probably come back to you and say you haven't secured a sufficient physical premise. You've claimed in the business plan you need a warehouse. You are going to hire 7 people, but you haven't shown how you're going to execute this with this small little office that's 100 square feet. So you just need to really be able to show the lease of the physical premise you've obtained makes sense in light of the business. It is a requirement, but the government doesn't usually tend to focus too much on this requirement, unless it's blatantly obvious that you've just not secured the sufficient physical premise. Even with after the pandemic, this has become a little bit more malleable. The government doesn't typically like to see co-working spaces. And sometimes they'll push back on this. But again, if you can show the government that the physical premise that you've obtained makes sense in light of the business that you're planning on operating, this shouldn't be too big of a hurdle for you within the petition. So if you are coming to the United States to under the L-1A new office to fulfill the managerial or executive capacity role, your qualifying role abroad must have also been as a manager or executive. So unlike other L-1 petitions, eligibility for the L-1A new office cannot be established through a specialized knowledge role abroad. So if you're a manager in the U.S., you should be a manager or executive abroad for this new office. Within the L-1A new office, you do not necessarily have to have employees before you apply. You just need to be able to show that the U.S. operation will support a manager or executive position within 1 year of approval. So in order to determine whether the U.S. operations will support this managerial or executive position, the government will focus on and want to see the scope of your office, the organizational structure, the financial goals of the company, your hiring plan, and they would want to see your explanation. So how are you going to accomplish these goals, the financial goals? They'll look at the size of your U.S. investment, the financial ability of the foreign company to pay the employee and start the business in the U.S. They'll look at who will capitalize the company, how will you support this. It is really just big picture. So everything you're claiming within your business plan should make sense in light of the evidence you're submitting. So sometimes with the new office, the government might say the foreign company will capitalize all the expenses in year 1. This isn't required by the regulation, so you could push back on this, but it's just important to show, you have a foreign company who can help support this U.S. company. Previously, when I used to adjudicate these petitions, I would see cases where maybe the foreign company had little to no funds in their accounts. They had little to no sales, just not a lot of activity abroad. So this would just be a red flag. So You don't necessarily need to have all the funds to capitalize this new office at the start, but you should be able to show that the foreign company would be able to at least support the U.S. company, pay the U.S. employee if needed. Another consideration with the new office that you might want to explain within your petition. So, will this foreign organization support the U.S. company with personnel, and in what capacity will the personnel they're claiming will support the U.S. office? Will it be full-time, part-time? So, what will the foreign positions role like? What will their roles be within the U.S. company? Um, so, for example, maybe you don't have plans to hire administrative support with this new office, but maybe the foreign company will provide this, or maybe you will perform these duties initially within this new office. It is understood that the manager or executive who's required to open this new office will be more actively involved in the day-to-day duties of this new office initially, and that's okay. You just need to show within 1 year this manager or executive will primarily perform managerial or executive duties, that they will have authority and intent to hire staff to get this company up and running, and to relieve the manager or executive from performing the operational duties of this new office. You need to show you'll have that sufficient personnel to support this new office. So we'll discuss now the next slide, the L-1B new office petition. So again, you can also apply for the L-1B new office. The L-1B new office would be for someone who served in a specialized knowledge role abroad for at least 1 year, and then that they are coming over to the U.S. to also serve in a specialized knowledge role. You would also need to show to the government that the employee possesses a specialized knowledge, and that the foreign and U.S. positions both involve specialized knowledge. And we will discuss in a later slide what is specialized knowledge. Again, you'll need to show that you've secured a sufficient physical premise to house this new office, and you must show that the petitioner has the financial ability to pay the employee and commence doing business in the U.S. So we did discuss that there are specific definitions for manager, executive, and specialized knowledge. So we will discuss each definition more specifically. So executive capacity means an assignment within the organization in which the employee primarily directs the management of an organization or major components or function of the organization. They will establish the goals and policies of the organization, component, or function, exercises wide latitude in discretionary decision making, and receives only general supervision or direction from higher level executives, the board of directors, stockholders of the organization. To demonstrate executive capacity, you would really want to show that this person will perform certain high level responsibilities. Show that they will primarily be engaged in these executive duties as opposed to the ordinary operational duties of the business. It would be really important to describe the applicant's duties in detail, explaining what they'll do on a daily basis, and show that they're the high-level duties. So really, if you're choosing to classify your employee as an executive, it is really important to describe this role in a manner that lines up with the definition and is supported by your evidence. As an example, so the definition states the executive has to direct the management of the organization. And an executive directs the management of the organization by controlling the work of managerial or lower level executives. They can do this directly and sometimes indirectly, but if you're going to claim executive, you would really want to show that you have a management to direct. So, are there other employees serving as managers? If you have just the beneficiary overseeing maybe 5 direct reports, nobody's a manager, then this would not be sufficient to satisfy the definition of executive. So typically with the executive claim, you are going to have a structure that's multi-tiered. So let's see what else. You would also want to demonstrate provide like a percentage of time for each duty. That would also help to show that the duties are primarily executive, the detailed organizational structure, and provide the detailed duties for the subordinates as well. This would also help the government see that you really are satisfying the definition. So again, the executive title alone won't be sufficient. You need to think about the structure of the company as a whole, how many employees there are, what positions they serve in, what are their duties. It's not just about the job title alone. It will really be about the substance of the job, so what you're doing on a daily basis. If you have a smaller company and maybe just one tier under the beneficiary, you might perhaps want to consider the managerial position or a specialized knowledge role instead. Okay, so now we will switch to Kelly, and she's going to go over the definition of manager.
Thank you, Katie. All right, so let's talk about the definition of managerial capacity. As with executive capacity, there is a very kind of strict definition. This is going to encompass both function managers and personnel managers. As listed here, a managerial capacity means that the employee primarily manages an organization, department, subdivision, function, or component of an organization, supervises and controls the work of supervisory, professional, or managerial employees, or manages an essential function. If they're a personnel manager, has the authority to hire and fire and recommend personnel actions. If a function manager functions at a senior level within the hierarchy of the company, and then exercises discretion over day-to-day operations of the activity or function. So there are a lot of kind of specifics in here that you will need to follow. They are very clear that kind of a first line supervisor who is, not who's supervising, kind of frontline staff is generally not going to be considered a manager. You do have to show that they are managing supervisory, professional, or managerial employees. So generally they need to sit somewhat higher up, on the hierarchy. If they are someone who doesn't really manage people directly, but because of the structure of the organization, they manage a certain function and then maybe have indirect reports who are actually performing that function, then you can apply, for a function manager. So just because the person doesn't directly manage anyone doesn't mean they cannot be, listed as a manager, but it is more difficult and more nuanced to prove that the person is a function manager. Again, because there's kind of a very nuanced line between are you performing the function or are you managing the function? And you do have to be managing it as opposed to performing it in order to qualify as a function manager. Kind of similar to executive capacity, the description of the job duties will be very important. You want to provide examples, context. It can also be helpful to provide kind of work product samples if you have evidence of the manager kind of, exercising that authority to hire, fire, promote, leave authorizations. Those can be very helpful. Showing that they operate, at that senior level within the function, within the department. So all of these are things that can be included. If the person does, manage others, if it's a personnel manager, it's going to be very important to show the organizational chart. Who are they managing? What are the job duties of the people they're managing? If you have access or are able to provide, what is the educational background of the people they're managing? Where do those people sit? If they are managers themselves, what kind of people are they managing? So you really do have to kind of get into the structure of the company to explain why it is this person qualifies as a manager. And you can also think about, what is the overarching structure of, both companies. So if there's kind of a smaller office in the United States, but it's supported by dozens of employees, abroad, that's something you can bring in to explain the overarching staffing structure to show why this person really qualifies as a manager. Okay, let's talk about specialized knowledge. So this is for the L-1B visa. As Katie mentioned earlier, this visa you can be granted for 5 years as opposed to 7 years. And it's for employees who have specialized knowledge. And similar to manager or executive, there is a specific regulatory definition that they follow. So specialized knowledge means special knowledge possessed by the individual of the petitioning organization's product, service, research, equipment, techniques, management, or other interest, and its application in international markets, or an advanced level of knowledge or expertise in the organization's processes and procedures. With either specialized knowledge or advanced knowledge, you have to show that the knowledge is not commonly held throughout the industry. So this can be quite a high bar to meet. It can be quite difficult to show that the person qualifies as a specialized knowledge employee. You do have to do a lot of explaining to show here's where the person got this knowledge. Here's how it's, kind of different from others within our company. Here's how it's different from others within the industry. And if it's somebody who, hasn't been working in the field very long, but is really key to the operations because perhaps they were, building up the organization abroad. Maybe they were the leader developing certain technologies or certain systems that are now really essential to the company. That can be a good time to use advanced knowledge. So perhaps if it's somebody who's newer in their career, but maybe has spent 5 years really, building up the operation, especially if it's gone from maybe a low number of employees to scaling very quickly. That can be kind of a successful approach. Other than that, you're going to really be using this category for people who do have, again, specialized knowledge. So something that sets them apart from the others. So if you have, an org chart and it shows there's 5 managers that all have the same job, and this person does that same job as all these other managers, and you're trying to send them over as a specialized knowledge employee, that can be difficult. Again, you have to really differentiate what this person's doing. How is it going to have a really positive impact on kind of the image, competition, research, product, services of the company in the United States? And so there's often a lot of supporting documents that you're submitting, work product samples, explanations within the company, specific job duties, tied to maybe some, metrics of success, that will all show that this person does qualify as a, specialized knowledge worker. Okay, let's talk about what documents you need to submit with your L-1 petition. So one will be a form submitted to U.S. Citizenship and Immigration Services. This is the form I-129, along with the L visa supplement. Along with this form, you're going to submit your supporting documents that show you meet all of the L, requirements. So that's going to be corporate documents showing you have that qualifying relationship between the company abroad and the U.S. company, proof that the companies are doing business. So things like tax returns, audited financial statements, lease agreements, invoices, payroll summaries. If the company is extremely large and successful, you may be able to submit kind of less, less of the financial documents and kind of more media coverage of the company or, publicly available information about the company. You also have to submit proof that the employee has worked for the company abroad for one continuous year out of the past 3 years. So you're going to show, pay stubs, personnel records, and then you also need to show that the person was in a managerial, executive, or specialized knowledge role. So that's where you're going to include the detailed job duties, the org charts, the work product samples, to prove that the person meets that qualification. You also need to submit proof that the role in the US is going to qualify as managerial, executive, or specialized knowledge, and you're going to submit similar documentation. Important to note that the roles do not have to be the same. So if you are an account manager, abroad, you're being transferred to the United States for a different job, that's okay as long as each job independently qualifies under that regulatory definition. If you're being transferred as a specialized knowledge worker for a specialized knowledge role in the US, you will be an L-1B, even if you had a managerial role abroad. It is also important to note that if the jobs are not the same, you will also need to show for the US role, how is this person qualified? What is it about their background or experience that allows them to take on this, new role, which often is a promotion. Okay, what do you need for a request for evidence? So requests for evidence are unfortunately pretty common for L petitions, although they have dropped in the past few years and now are a bit, on the rise again. From 2019 to 2021, RFE rates were very high, over 50%. Recent data, more recent data that we have, shows RFE rates more in the 30s than the 50s. So it has improved, but, under the new administration and the presidential proclamations regarding enhanced vetting, we are starting to see more requests for evidence. Most requests for evidence challenge whether the applicant meets this very strict regulatory definition of manager, executive, or specialized knowledge worker, even if kind of there's other things in the request for evidence, often they will kind of throw this in as well, and just say, whatever was submitted was not sufficient. When you go back, you really want to make sure that you're providing kind of detailed support letters, detailed organizational charts with, information. And these should be supplemented with objective evidence. So you don't want to be in a position where the government can say, well, you've just submitted, letters and an org chart, and how do we know this is true? It's really much more compelling when you can back it up with here's an example of something they did. Here's where they drafted the employee handbook, or here's the very important contract they signed off on, that helps to demonstrate that they do have, the executive, managerial, or specialized knowledge experience that's being outlined in the support letters. Okay, let's talk a little bit about timing and dependence. So the process is that the L-1 petition must first be approved by U.S. Citizenship and Immigration Services. Regular processing times are several months, but you can pay an additional fee to get a response within 15 business days. This can be an approval, denial, request for evidence, or a notice of intent to deny. If it is, a request for evidence or notice of intent to deny, you'll prepare a response, submit it, and then generally they'll issue a final decision within 15 business days after that if you've paid for premium processing. Um, After the L-1 petition is approved, then if the applicant is outside the United States, the next step would be to schedule an appointment at a consulate to get an L-1 visa stamp. If you're already in the United States in a valid non-immigrant status, let's say you were on a B-1, on a brief business trip and you filed for a change of status, then you can change your status and you wouldn't need to immediately leave. You could start working under the L-1 approved petition and then at a convenient time leave the US to get a visa stamp to allow you to travel internationally. Your spouse and any unmarried children under 21 can accompany you on an L2 dependent visa. The spouse can work anywhere, and children can attend school but are not permitted to work. Okay, a very common question. Does an L1 lead to a green card? Sometimes there's an impression that, by having a temporary visa for some length of time, you automatically, are eligible for a green card. And that is not the case. However, if you do qualify for an L1 visa, an L1A visa, it is possible you could also qualify for an EB-1C multinational manager or executive green card, which would allow you to live and work in the United States long term and eventually apply for US citizenship if you chose to do that. The requirements for the EB-1C are similar to the L-1A, but there's a heightened standard because the L-1A is a temporary visa and the EB-1C is a green card that allows you to live and work in the United States, full time. So you do still have to show there's a qualifying relationship between the company abroad and the U.S. company, have to show that the companies have been doing business, and the U.S. company has to have been doing business for at least a year. So there's not kind of the equivalent to a new office L1 for the EB-1C. You would have to wait until the U.S. business had been, operating for at least a year before filing. The employee does have to have worked in a managerial or executive role abroad. So if you, were working in a specialized knowledge role and you were transferred to the U.S. on an L-1A as a manager, you would not be eligible for the EB-1C because your role abroad was not managerial or executive. So if you are a specialist, then you would need to go through the PERM process. We'll talk a little bit about that. But just to go back to the EB-1C, again, you have to show that you've worked in a managerial or executive role abroad, that you will have a managerial or executive role in the United States, or you already have one. The dates of employment abroad will be adjusted. If you've been in the U.S. for 3 years, for example, they'll look back at the 3 years prior to you entering the U.S. on the L1. The benefit of the EB-1C is you can skip the normal kind of labor certification test, which can take quite a long time with the Department of Labor. The EB-1 is also one of the only green card categories right now that is still current, meaning that you can concurrently file for your I-140, which is the first step, and also your green card application, your I-485. So this is a very attractive category. But you do want to keep in mind, like, let's say that you had a very difficult L approval, and it was a struggle, big RFE. That those same issues may come up at the EB-1C stage, and they may not accept it, right? Like, just because you got the L1 approved, it doesn't mean they're automatically going to approve the EB-1C. And if it was a very difficult approval, you really want to think of whether that's the right path or what information you could provide to show that you meet the criteria. If you're not eligible for the EB-1C, you're on an L-1B or you were a specialist abroad, you can go through the PERM process. And this is the process where a U.S. company will, sponsor an employee for a green card. It's a three-step process. The first step is kind of the company is going to get a prevailing wage, saying how much they need to pay in the future when the green card is granted. They're going to test the U.S. labor market. That means they're actually going to place advertisements, see if there's any willing, qualified, and available U.S. workers for this job. And if there are, then the process cannot continue. If they don't find any willing, qualified, and available U.S. workers, they can file, for the PERM with the Department of Labor. Those are taking about 16 months right now, so it's quite a long time just for the processing times. If that's approved, then the company can file an I-140, which will show that they can pay the prevailing wage and also that the employee has all the requirements for the job that were listed in the U.S. kind of labor market test. If that's approved, and then once the priority date becomes current for the category, which is usually going to be EB2 or EB3, then they can go ahead and file for the green card. So it is kind of a longer process, and something that you want to start planning for early if you're on an L1B, because you will kind of run out of L1B time, at the 5-year mark. All right, so we've reached the end of the presentation, and I don't think we have received any questions. So I think we will close here. Thank you so much, Katie, for sharing your knowledge. Thank you, everyone, for attending. If you
Thank you.
have any follow-up questions or want to discuss anything with us, please set up a consultation. Thank you.